Good day, Your Honor, and may it please the Court. The case we're going to review today, the first case we're going to review today, is Gideon v. Wainwright. This case revolves around the Sixth Amendment's protection from the courts in the form of the right to have counsel in criminal matters. The facts of the case are the plaintiff, Charles Gideon, was poor, had a bad reputation, which led to him being assumed to be guilty instead of assumed to be innocent, and was arrested falsely in regards to a robbery. At that time, Florida only provided counsel to defendants in capital criminal cases, not anything less. This was a simple felony case, and thus no counsel was offered, even though the plaintiff had requested the court appoint him defense counsel. It is also worth pointing out that the plaintiff only had attained a 8th grade education and had no means of paying for his own counsel. The court opted not to appoint counsel, and Mr. Gideon was swiftly found guilty. The prison that Mr. Gideon was sentenced to had a library, which he utilized in addition to his 8th grade education, to write an appeal to the Supreme Court, which was sent via letter on prison stationery. The Chief Justice of the Supreme Court opted to hear the case, and the case was found in his favor. This becomes the foundation of the right to counsel should you not be able to afford it, i.e. public defenders. Good day, Your Honor, and may it please the Court. The case before us at the moment is Mendez v. Westminster. This case turns on the 14th Amendment's Equal Protection Clause, Section 1. It is as applied to school accommodation in instances that show that the Plessy v. Ferguson separate but equal is almost never the case. In the basic facts of the case, in 1947, an all-white school district in Orange County, Westminster, the city of Westminster, had separate schools for Latinos, Mexicans as they referred to at the time, and white students. The schools for Latinos were plainly inferior: no playground equipment, less books, less funds, less in general. Tools. The case was around Mendez suing the city of the school district of Westminster. It was fairly easily proven. The case went up to the Ninth Circuit Court of Appeals and was ultimately decided in favor of Mendez. Thank you. Good day, Your Honor, and may it please the Court. Today I will be advocating in favor of reversing the recent ruling in Dobbs v. Jackson Women's Health Org. The decision holding that states could set their own standard with regards to abortion has clearly led to unintended consequences. I believe the court would agree. The assault on the Fourth Amendment's implied right to privacy is the foundation of far too much law to overturn so casually. In several of the Supreme Court justices' confirmation hearings, they were specifically asked about stare decisis and Roe v. Wade. And on multiple occasions, these justices were declared Roe to be precedent. And the following case of Casey being precedent upon precedent. Casey reaffirmed Roe, and that is based on U.S. 505 U.S. 854 and 869. The second part of the decision involves choosing to ignore stare decisis. Stare decisis, of course, is the principle that once the court has ruled in a area, it should be far more unwilling to simply go and overturn an existing ruling. The law is supposed to be grounded in law and not in politics or in new members of court. And unfortunately, the current decision definitely lends the appearance that simply adding conservative members to the court has, in fact, changed the interpretation of the law, regardless of precedent upon precedent or super precedent, as in order to quote the Supreme Court justices themselves. The court was warned that deciding to overturn Dobbs would break the court and destroy its legitimacy. I would argue that those forecasts have in fact been proven fairly accurate, and I would beseech the court to reconsider their position for the sake of the court and for the sake of our justice system and our country. Thank you.